This is Michael Cowan, and welcome to Trial Lawyer Nation.
You've got to have the right case, because if you take it up and it's the wrong case, then you can make some really bad law that's going to affect a lot of plaintiffs.
There's always an answer. The joy is in finding.
One of the reasons that I love being a lawyer is this exact process.
The way we live our life has nothing to do with the presentation sequence at trial.
As trial lawyers, we pick up and move on and keep going.
You're losing or gaining 1 out of every 10 jurors, which can really make a huge difference in the ultimate result of the case.
Whatever you think about, you create.
Learn all you can and never stop. And then have the guts to try case after case after case.
Welcome to the award-winning podcast Trial Lawyer Nation, your source to win bigger verdicts, get more cases, and manage your law firm. And now, here's your host, noteworthy author, sought-after speaker, and renowned trial lawyer, Michael Cowan.
Today on Trial Lawyer Nation, we've got a good friend of mine, Ed Ciarimboli. Ed is a great lawyer from Philadelphia. Has a wonderful practice, also speaks a lot. I know him from the speaking circuit, teaches what he learns to other lawyers. And he also recently was one of the few lawyers that's been able to not just try a case, but successfully try a case in our era of COVID. And we're always wanting to learn more about, how can we get our cases to trial and what do we need to do to try them successfully during these challenging times. So Ed was nice enough to agree to come on the show. How are you doing today?
I'm doing fine, man. And thank you for those kind words. And it's really an honor to be asked to be on your podcast. I was looking just before we got on, I was looking at some of the people that have come before me, and pretty impressive list. So
I feel more impressive now. Thanks.
I feel pretty humbled, So thank you. And it's great to see you. We haven't seen each other in too long.
So I can't wait to once I get, 2-3 weeks after my second dose, I'm firing up the jet and going around the country. I'm gonna start seeing people having fun.
Absolutely.
I'm done with this. I'm going to be safe, but I'm done with this.
I completely agree. We'll be drinking some Pappy Van Winkle together.
Absolutely, my friend. I'll bring it with me. So, tell me, before we get into your trial, because you had a trial back in November, but not everyone on the podcast listening knows you. Tell us a little bit about yourself and your background.
Sure. So, I have 3 offices in Pennsylvania. We have an office in Philly. We have an office in Kingston, Pennsylvania, which is right outside of Wilkes-Barre. And then we have an office in Scranton. And I'm sure that, everybody knows Scranton from literally from the office. So, we have 12 lawyers in my firm, and we handle, a whole host of things. My practice primarily is handling, commercial motor vehicle cases. I would say that about 75% of my practice is doing that. The other 25% is, handling catastrophic cases, including medical malpractice and products liability and things of that nature. But I've been fortunate, as you said, I do a lot of speaking, and I was fortunate enough to start getting really heavily involved with AAJ and teaching probably about 9 years ago. And, that really allowed me to meet great people like you and really, develop, my skills as a lawyer, both from a teaching perspective. And then I'm always stealing something from somebody at all the seminars that, that I teach at, or colleges that I teach at. And it's something that I'm pretty passionate about. Right now I'm the co-chair for the NCA board for AAJ with a good friend of mine, Carl Solomon. And that's just been, that's been a blast. I wish it was not during COVID because, we would have a lot more fun, but fortunately our term is 2 years. So hopefully next year we'll be able to get to see each other a lot more. And it's a really, tight knit bunch and close bunch. But, I try a lot of cases and, a number of years ago, a good friend of mine, he's since passed on, his name's Paul Scopter. He pulled me aside, it's probably 6 or 7 years ago, and he said, you better get really good at trying cases. And I said, I love trying cases. He goes, no, I mean, you really got to be good, get good at being in the courtroom, because you're the worst lawyer I've ever seen at settling a case. He's like, you absolutely, positively hands down, I don't know what it is. Every time I'm talking to you, it's a zero offer case. He's like, you're terrible, absolutely terrible.
That may be case selection too.
Who knows, But he's like, hey, you're absolutely terrible at it. And I said, you know what, you might be right. So really have focused on getting as good as I can in the courtroom, as comfortable as I can, and always trying to push the envelope. In terms of how we try cases, we're certainly now we're certainly trying them differently than we did, a year ago or 2 years ago, whether it's from a technology perspective or, from a witness prep perspective or whatever it may be. I mean, this COVID trial, which I know we'll get into, it was a 180, a complete 180 from everything that, we have worked on so hard over the last 7 years, in terms of, connecting with the jurors, to exhibits, to visuals. It was really, really pretty fascinating.
So one of the things, some of our listeners are really experienced, accomplished trial lawyers, but we have a lot of listeners that are working. They're on their path to becoming an experienced, accomplished trial lawyer. And one of the things that people seem to always want to know is, what have you done? You've mentioned like going to AHA stuff, but what have you done to develop yourself as a trial lawyer?
Yeah, I think the biggest thing that I've done to develop myself as a trial lawyer, outside of the, really investing in education. And when I say investing in education, not just popping onto a webinar, but really like going someplace and, really focusing on the different aspects of trial outside of like direct or cross, but how you're doing it, how your presence in it, your presence in a courtroom, your voice, what you're doing with your hands, your body language, where your movement, and I've been very fortunate over the last 6 or 7 years to work with some really outstanding people, that have helped me along that path, because, when you start to take a step back and then look at how you're delivering what you're delivering, it's pretty fascinating. We all like to think we're pretty good. And then all of a sudden, you start recording yourself and you're watching it and you're breaking it down and you're like, oh man, that's just, it's just terrible. And I know you've done that, Michael, and it's humbling.
I'm getting ready to start next week of doing, daily opening practices on video. And because I've got a case that we're hoping to start trial on February 1st. And it will be by Zoom. So the video is really important because that's what the jury is going to see, and not just practicing our camera people and stuff, but that means I have to watch it. And it is painful to watch yourself because we're not as smooth as we think we are.
Not even close.
Do you want to ask who you've worked with to develop yourself?
So I would say over the last 6 or 7 years, so I've worked, I worked with Paul Scopter, Philip Miller, Rodney Jew. We saw each other out at Rodney's.
Yeah.
God, it seems like forever ago, doesn't it? It was just last year. I've worked with Catherine James and Alan Blumenfeld, and a guy named David Mon, and he's out of Minnesota, and he was terrific. He came from the theater, and he was a producer, a director, and so worked a lot with him on delivery in the courtroom and movement, because I was one of those people that I felt comfortable in a courtroom, too comfortable, if that makes any sense.
Uh-huh.
And so one of the things that he really drilled into me was, look, just like if you're in a theatrical production, the actors, they don't just wander all over the stage. Like, they move for a purpose.
Right.
And so when you're in a courtroom, you should do the same thing. You should move for a purpose, and otherwise stand still, damn it. Stand still and talk. And I tell you, it was one of the most difficult things that I had, really overcoming, because, I wouldn't say I was one of those people that's like pacing back and forth in a courtroom, but I just felt comfortable. I would move, and and when you when you start to watch that, and one of the things that he made me do, and he said, look, I played basketball in high school and my first year in college, and he said, you watch film, and that's how you become better, whether it's shooting a jump shot or playing defense or whatever. And he said, being an actor is no different. They have to watch film. And he said, now being a lawyer, if you really want to improve on these skills, you got to put in the work and you got to do those things. And so I probably watched countless hours of myself just, looking like an idiot, because I'm like, what am I doing? Like, that doesn't even make any logical sense. But, I've had, the good fortune. I worked with a woman named Melissa Gomez. She's does a lot of work, with some of the folks in AIEG that I know you're a member of as well, Michael. And, Melissa does some great jury stuff. A guy named Harry Plotkin, who Harry worked on, actually was part of the team on this last case. Harry's based out of LA, and really, really good trial consultant, especially when it comes to kind of putting together demographics for, what good jurors and bad jurors are. So those are just, some of the people that I've had the, been very fortunate, to work with over the years. And then just to all my, brothers and sisters in the, in the different organizations that, that we're in, just really learning from them and how they do things, and why they do things, and trying different things and failing and figuring it out and failing again until you get it right.
Absolutely. That's do you have any kind of, there's some people that are in the reptile school, the trial lawyers college school, the different, do you have a particular approach you take, or are you just
I'm not, and I'll tell you why. Because I don't think that there's one size fits all. And like for example, when we were out with Rodney, I love Rodney, and I love the stuff that Rodney does. But for me, the thing that I feel a little bit more comfortable with is not using all boards. It's having a mix of medium, whether it's a board and a PowerPoint or a visual or whatever it may be. And then, it's, if you're in the reptile, it's like, you got to do it this way all the time. And if you don't, then you're doing something wrong. And one of my teaching philosophies has always been, look, there are some fundamental things that you have to master. And whether that's in a deposition skill or a trial or whatever it is. And then once you master those fundamentals, from there, you should craft your story of your case around the case, because, not every single story is going to fit for every single case, nor should it. And so that's kind of how, we've really, approached the case. And, I've done, like with Catherine James and Alan Blumenfeld, I've gone out to California and, sat with them, a place called the Culver Hotel, which is this really cool hotel, and just locked ourselves in a room for a couple of days, trying to figure out like what's the best story for this case. And when I say story, meaning, the sequence of the witnesses. And one thing that I think that people, they really overlook is the witnesses have, the sequence of the witnesses is so vitally important, because each one of them plays a different role and has different importance. And I know you've done some work with Sari, and that's one of the things that she's like, she's really, and I've read a bunch of her stuff and watched a bunch of her stuff. And I know that that's like something that she's like really, really on top of. Like, you got to know where these people fit. And if you don't,
that's something we've been, and I wish I could talk, I'm dying to talk more on this, but I know that my opposing counsel will probably listen to this between now and trial. So I'm going to have to hold back a little bit. If we get to try it, then I'll give another recording later and talk about what we did. But we've really been, struggling is the wrong word, because like we have a story that could be told in two different sequences. I mean, one is like what happens in the crash and then the company part, and one is the company part and then what happens in the crash. There is a conventional wisdom on how to do it, but then there's some thoughts about what's right for this case. And to just say, Rodney Jew says to do it in this order, and I love Rodney and I respect Rodney, but I don't believe that sometimes that's the most persuasive way to do it, because sometimes people have to know that something bad happened before they care about what the company did. The company's wrongdoing only makes sense after you know that something bad happened.
Yeah.
And then everything means more. Where in other cases, where you want to make it, like I was working on a product liability case and we focus grouped it. And, my client was a passenger in a car. He got in the car on Christmas morning, said he didn't know, but, who knows? What happened is that his friend and everyone else were drinking all night, and he went to bed and he woke up and his friend was just as drunk as a skunk. And he got in the car with him and they drove, and then took a curve too fast. They did a 180, went backwards into a tree. The seat collapses backwards. He ends up getting paralyzed. On top of that, it was a 93, 94 vehicle, which is the front half was a 93 and the back half was a 94. And it's called a clip. They've been welded together because each half they're from two different cars. But the seats neither one was a rear-end collision, so it shouldn't have affected the seat. But, you had some challenges in that case. And so when I structured the opening, we started off about talking about the company's knowledge, and we showed the crash test where the seats collapse backwards when they're doing crash tests to test for the fuel tanks. And then we went into 9 or 10 prior cases where this make and model car had been rear-ended, and either the person in the front seat was killed, the person in the front seat wouldn't kill the kid behind them or paralyzed the kid behind them. So that when we got to our case, it was just another one of these cases with some weird facts. It wasn't. Yeah. And so, different cases call for a different sequence.
Yep. Yeah. No, believe me, I completely agree. And, again, I think there's some fundamentals that have to be worked into each one of them, but you gotta work hard to find what fits for your particular case. And if you don't, I think you're doing a disservice to your client if you're just walking in there and you're trying the same case in the same way, every time, because it's just a cookie cutter approach, and it's certainly not something that we do. I know it's not something that you do either. So
and it also lets the defense lawyers get your transcripts, file the right limine, make them anticipate your arguments. I mean, there's some good, but I just think this whole one size fit all, and society changes. I mean, like early in my career when I was trying to lot of just like soft tissue car wreck cases, I had a method that I would get an excess verdict about every third trial. Which is for those cases are good because most people get meds plus 2,000 and. I'd get one case where we'd get under a meds. I'd get one where I'd get like, 2 or 3 times meds. And I'd get one where we'd have like 3,000 in meds and I'd hit between 40 and 90,000. Yeah. And, so it averaged out pretty good for a baby lawyer, trying to make a name for himself, trying to make a little money. And at some point, my formula stopped working. I was doing the same thing I'd done 2 years before, but it stopped working because the societal attitudes had changed.
Yep.
And so, we had to go back and retool and revisit how we were trying our cases.
Yep, absolutely. You got to do it. And I commend you for doing all the hard. It's just doing the work.
Yeah.
You just got to do the work.
It's fun. It's like, I haven't done this for a long time, but I've worked past like 3 a.m. a couple of times, and someone said, "Oh, I feel so bad for you." I said, "Why?" I'm having a blast. If I was like drinking wine till 3 a.m, would you feel bad for me? I'm doing the same thing. I am having fun.
I love it. And that's, you get a rush out of doing it. And
you do.
I would say if I could be in trial 12 months out of a year and just be focused, in that process and living I'm the happiest guy in the world.
Right.
I'm not, there is nothing that I'm stressed about when I'm doing that and going through that process. And I mean, obviously, the stressful things are making sure that we take care of our clients and our clients' families. But for me personally, I mean, it's just fantastic. I love doing it. Yeah, it is. It really is a blast. It's a blast.
Each year, the law firm of Cowan Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach Delisi Friday by calling 210-941-1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowan to speak with you in person or by phone to discuss the case in detail. And now, back to the show.
Well, let's start talking a little bit about your case then. So tell me, you had a trial in November, so during the height of this pandemic.
Yeah.
What kind of case was it?
So it was a really interesting case, a little quirky case. So there was a company and this company was buying this machine. And so they buy this machine, and it's called a DMEG machine, and it's a molding machine. Big machine. It weighs about 9,000 pounds. It's got hydraulic fluid in it, about a 55-gallon drum of hydraulic fluid in it. And so what happens is this company purchases this machine from a broker. The broker's out in Ohio, and the machine is located in New Jersey. So they have to get this machine shipped to their facility. And what they do is they call up a crane company and, for the rigging and transportation. And they don't tell them anything about the specifics of the machine. They don't tell them that there's hydraulic fluid in it. They tell them the approximate weight, but they don't give them any of the, manufacturer's recommendations or anything like that. Company goes down, and they are in the process of moving this machine. It's two guys. They're both riggers. They're working a forklift. And when they pull the machine out and they're going to put it up onto the flatbed truck, they put it on, and then they have to pick it up and basically they have to teeter it in order to, put the cribbing underneath of it to transport it. And when they do that, what happens is the hydraulic fluid had not been drained in the machine. There's no bladder in this tank. The fluid sloshed to the side and to the front. The machine tipped over. Our client was standing off to the side of the machine, but he was in a pinch point, which was one of the things that the defense was keying on in the case, and the machine crushed his head.
Oh my God!
Yeah, I mean,
he worked for the crane and rigging people, or who did he work for?
So he worked for the rigging people. Yeah, he worked for the rigging company. So we couldn't sue the crane company because of the workers' compensation, bar.
Right.
And so we ended up suing the broker of the machine initially, and we ended up suing the company that had purchased the machine. And so very fortunate and doing the work that you and I do a lot in terms of commercial motor vehicles, I knew the federal motor carrier safety regulations 100 million times better than the defense did.
Yeah.
And so what we were able to turn it into was that we had a shipper, a carrier, and a receiver.
Yep.
And in this particular transportation cycle, the shipper was this company, and they were also the receiver because they were shipping this machine from point A to point B.
Oh, because it was their machine already. They already had title to it?
Right. And so there were some great documents between the broker and this company, and those documents were really, really ended up being really critical in the case, which said that this company was responsible for the rigging and transportation. And now you have hydraulic fluid in this machine, which is a hazardous material, and qualifies under the class. It was a class one hazardous material, and so it imparted a whole bunch of responsibilities on the shipper that they said, yes, we have to follow this. Yes, these rules apply. We know all about hazardous materials because they were in the business that they were in. They had tons of injection molding machines with tons of, tens of thousands of gallons of hydraulic fluid. So they knew all about these rules. They just didn't follow any of them. And so what ended up happening was they were the shipper under the Code of Federal Regulations and the FMCSR. They were supposed to inspect it. They were supposed to classify it. They were supposed to make sure that it was safe for transport. They were supposed to make sure that the company that they were hiring was able to transport hazardous materials across state lines. They didn't do any of this. The defense of the case was, we hired this company.
Yeah.
We hired this company. That's it. And that was their entire defense. That was from, other than our guy was standing in the wrong place, their entire defense was, we hired this company, that's it, and we don't have any responsibility.
And I can see that being a pretty good, like we hired a professional company to do this for us, and, they hurt themselves doing it, but that's on them. If they had questions, they needed to ask it,
It's exactly right. And so, the nice thing about, the regulations, they were pretty specific, like that, they said that, the shipper, these are the responsibilities that the shipper has. And fortunately, when we took the depositions of some of the, corporate people, they were terrible. I mean, they were flat out terrible. Every time, like, we showed them the document that said, okay, you say you're responsible for rigging, you're responsible for inspection. It's right here in black and white. Did you do an inspection? No, we didn't do any inspection. And one of the neat things that we did in this case is during the deposition, or before the deposition, we had done some focus groups to get us ready for the deposition. And one of the things that kept coming up was about the inspection, and it was like a checklist. And the one woman in one of our focus groups, she's like, yeah, like those people, like those guys are walking around with the clipboards and they're checking stuff off all the time.
Yeah.
And so in the deposition, we had a PowerPoint that it was a clipboard that had like a yellow pad that had all the elements that they were supposed to do for an inspection. And we just checked them off. No. And it became one of the core exhibits in the whole trial. It was a very, super simple exhibit. Didn't cost us more than probably, I think we bought the clipboard on like stock images for like $1. And it was just a really clean, powerful image. But that was the premise of the case. Our client was a wonderful man. He was 61 years old. He had an adult daughter, who was, Stephanie was 32. He had 2 young, beautiful grandchildren. And this guy was amazing. I mean, he just was a really good human being. So much so that one of our key damage witnesses in the case was his ex-wife.
Oh, wow.
Yeah. His ex-wife testified what an amazing person she was. And one of the interesting stories, and one of the jurors afterwards actually said, like, wow, that was really powerful. They got married young, didn't work out. They got divorced, but they had a daughter. The ex-wife remarries, and they end up having 2 more children. And our client, George, wanted his daughter to make sure that she was in a good family environment. They had his ex-wife and her new husband buy a house. He remodels the whole house for them.
Wow.
Never doesn't charge him a dime. Ends up like coaching his daughter's on the softball team, ends up coaching the softball team. And then his daughter ages out and he ends up coaching their daughter. It just was like, we just had like really great stuff, and everybody from the company that he worked for, they were just outstanding. I mean, these were tough guys. These were riggers. 30, 40-year riggers. And, they just came into a courtroom and just completely broke down talking about it. So it was pretty powerful stuff. And, it's interesting, like those are some of the intangibles that I think that defense lawyers, especially, insurance defense lawyers, they just overlook that stuff.
Yeah.
It's just that, it's always about check the box. What were his wages? What were his medical bills? And we didn't put any economics into the case because they were the anchor on them made it about $400,000, and it was a relatively low anchor. and we didn't want it in the case. So, and I'll tell you how that ended up. The case settled at trial after I crossed their economic expert, and we could talk. Yeah, it was really really fascinating. But that was the case, and it was set for trial. It was originally set for trial in September, and then the judge had continued it to November, and she was adamant that we were going to try the case.
Before we get to the trial, I've got a question. So you really use federal regulations, that are specific to trucking to really make your case against the target offended as a shipper and as a receiver. A shipper, for people that don't do a lot of trucking, is the company that hires a trucking company to ship something. The receiver is where they're delivering the goods, the party that's going to receive the goods.
Yeah.
Did you kind of work up the case, before you got into depositions? Did you figure this stuff out on your own and look up the regs and know the regs, or did you hire an expert to explain to you what the regs were?
Well, I mean, I had a fairly good understanding of the regulations. The thing that I was not 100% sure on was just the hazardous material aspect of the federal regulations. My expert's a guy named Ken Lacey. He used to run Jones Motor Coach. Great expert. I've used him a whole bunch, and he's just a fantastic expert. And I called him up and I said, Ken, I have like this. Here's the scenario. I think it fits into this, but I'm not sure. And Ken said, hold on, I'm gonna make a call. And then he texted me and he said, expect a call from this guy Jody. I said, oh, okay. So 15 minutes later, I get a call from this guy Jody. Jody owns a company that specializes in moving hazardous materials.
Oh, wow.
And yeah, they move like fracking water, hydraulic oil, everything else. And he's like, you're 100% right. That falls right directly into the classification of a hazardous material. And, these are the non-delegable duties that a shipper has whenever they are going to be moving hazardous materials, especially, across state lines, so that it's in interstate commerce. So that was kind of, I had that basic knowledge, but I, very candidly, I think I might have had one case, 4 or 5 years ago where the truck was hauling hazardous materials and got into a wreck, but it didn't involve like the nitty gritty of what it was, the shipper's responsibilities, things of that nature. This was the hazardous material that they were hauling, and the driver fell asleep.
Because what I found, is, and I love a lot of the experts we work with, but we can't just go to the expert and say, here are the facts. What are my theories? Because they're going to miss things. I mean, because they're industry people. They don't always think of every possible theory. The other thing is, they're looking at making so many $100s an hour. They're not looking at, no one has more of a motivation on your case. I mean, I've got a case where I'm getting ready for trial where cell phone's a big issue. When we finally got the cell phone files from our expert, where I could go look too, I find all kinds of stuff that he didn't point out.
Yeah.
Because I'm there at 2 a.m. digging through this line by line by line where he was looking for big stuff, and it's an overwhelming amount of data. I'm not faulting him, but so and it's not that I'm telling him what to say. I just ask him, hey, look at this. Does this show this or not? Oh yeah, it does. And same for the safety experts. I mean, you kind of have to like this is kind of what I'm thinking. Am I right or wrong? And you don't, obviously you can't tell them what to say, and you don't want that because people need to believe what they're saying to be credible testifiers. But to just go, I'm going to go take a case and hire an expert, have the expert tell me how to do my case. I mean, it's not going to work.
No way. No, it's going to fail, right? Fail on the spot. It really is. Yeah, absolutely.
So you were talking a little bit about the jury selection process. So how did you do jury selection in a way that was safe for the jurors?
Yeah. So we picked the jury at an old theater, and it was a huge room. And I said, I was more nervous about this jury selection than any other jury selection I've ever done. Cause just the fear of the unknown. We even though we had gone to the facility to kind of scope it out ahead of time, you just had no idea. And the judge just did such a phenomenal job. Like, she gave a speech in the beginning of jury selection and talked about the importance of jury selection and how, in 100 years, how many times that juries had gone on throughout world wars, civil unrest, you name it. And it gave our case just this air of importance. And I think that everybody that was there felt it. And I think it was really important for her to do that. And then from a safety perspective, everybody was social distanced. And then what she allowed us to do was go into a separate room. Everybody was around spread out. And she basically let me individually voir dire the first 40 jurors.
Oh, wow.
Which was amazing. I mean, really, really amazing, and really was needed, because in our workup to the case, and then figuring out who were going to be our good jurors, bad jurors, and then kind of our neutral jurors, we were able to get a treasure trove of information that I truly believe that our case was won in jury selection. In that particular case, it really was.
Just based on the information that you got?
Yeah. So I worked with Philip Miller doing, we did 6 online focus groups. So we ended up polling about 200 people before the case. And what we did is we gave them, the first group that we started with, we gave them the narrative, and, we laid it with the sequence always remained kind of the same. Like, we started with just this guy's head was crushed by this machine. Why did it happen? And then we went into, the company and the sequence of events, and then talked about, the damages. And so then each time we added a particular fact that we thought would move the needle, and it did. And then we were able to get such amazing data. I mean, we were able to ask so many questions that you wouldn't normally even get into during a live focus group. And one of the overriding themes for us from all of those groups was that people who relied upon other people to do their job safely, those were going to be our best jurors. Meaning like laborers, like people who, they needed information from somebody else in order for them to do their job the right way and do it safely. And if those people failed to provide them the right information, then those were going to be they were willing to hold other people accountable for not doing that. And then the other thing that was fascinating for us was people that actually, because initially we were like, they're running a forklift. They ran it wrong. The guy who was operating the forklift, there was some blame that was trying to be cast on him that he ran the forklift wrong. It was the exact opposite. People who had experience running a forklift and doing rigging were fantastic for us because they fit right into that mode or model of the individuals who required information from other sources to do their job safely, and that when they didn't get it, those people, the up the line people, the bosses, the companies, they were putting these workers at risk. And so that once we were able to, we had all that data, and then we gave it to Harry Plotkin, and Harry ran everything through a program, and we found out like these jurors were going to be in our sweet spot. And it didn't really matter, like age didn't really matter. Socioeconomic factors really didn't matter. It was just, this was who they were and what their mindset was. And so, we had 12 jurors, 2 alternates. And when we were going through, we ended up, of the first 40, of that first 20, we ended up having 6 people that had experience, either they themselves running a forklift or seeing people running forklifts or were laborers. And so the defense the whole time was thinking these were going to be great jurors for them.
Yeah.
And it totally blew them out of the water.
That's awesome.
Thank you to everyone who attended Cowan's Big Rig Boot Camp in August. We had an excellent virtual turnout this year and are already thinking of how we can continue to raise that bar for next year. If you'd like to attend virtually in 2021, be sure to mark May 20th, 2021 on your calendar now and save the date. To stay updated with details as they become available, visit bigrigbootcamp.com and sign up for our mailing list. And now, back to the show.
Did you notice any difference on the kind of the composition of the people that showed up for this trial versus the kind of people that normally would show up for a trial in the county?
You know what? Honestly, there was no difference. There really was no difference. I mean, we had people from age 18 to 90, and from a very cross section of the population. I mean, we had people that were owners of companies. We had people that were students. We had people that were laborers, teachers, firefighters, policemen. I mean, we had we had a lot of people. I was stunned, and it actually gave me a lot of hope, because of these 80 people, none of them fought hard because of COVID when they showed up to get off of jury duty.
Wow.
Yeah. Not one single one of them. And that was one of the things, obviously, that we were, very concerned about. And then just in terms of how, they did the selection, like they ran it pretty well. They really did a good job. The judge did a really good job. The judge, I think, was more liberal with cause challenges just because of COVID. If somebody, had a work issue or a childcare issue, she was very, even if it wasn't an overwhelming issue, she was very quick to get them off the jury, so that we really seated 12 people and 2 alternates that were there was no groaning, no groaning.
How about the courtroom setup? How did you?
Michael, this was the thing that gave me a lot of sleepless nights, because so they put the jurors in the gallery, all spread out. The 2 alternates were in the very back of the courtroom. What they did then was they had 2 huge screens that were set up on each side of the gallery. The witness was in the jury box, in the middle of the jury box, and then the judge. So the judge is here, witness is over here, jury's way over here, and as I was saying before, one of the things that we've worked so hard on over the years is, the best thing that you have in a courtroom is you, in terms of your body presence and your voice and your movement, and making that connection with the jury, and being there with them, guiding them through this trial. Couldn't do any of that, because now I'm 80 feet away from the juror who's in the in the back of the courtroom, and my witnesses as well. So what we did is, we streamlined this case completely down to its bare essentials. And so almost every question on direct or every question on cross had some corresponding visual that was on the screen that the jury could see and connect with. And so that was a lot of work. When you're looking at your questions, you're like, okay, every question has to have something that they're going to be able to focus on, so that how are we going to make a connection with them otherwise? We have to make sure that we can check in with them. Hey, juror number 7, you're in the 3rd row. And the judge let us do this. Can you see everything that's on there? Yes. Can you hear the witness? So we were able to do that. And that became really important, because the defense didn't have anything. Nothing at all. They tried the case just like it was your normal traditional case. Defense lawyer standing up at the podium, his back is to the whole gallery, and he's talking to a witness, and they are literally looking at his ass while he's asking questions, and it's like, it was mind blowing. So he was making,
not about the witness, about the jury.
completely, all he was concerned about was just asking questions of the witness. But that was one of the things that, really was, I would say difficult, challenging, and very rewarding, because we practiced it a lot. And when we got it down, when we got into the courtroom, it just flowed so easy, because now, it was like, okay, next, what's the next image? And then ironically, I found myself not even needing notes at all throughout pretty much the whole courtroom, because the visual was right there in front of me, which triggered the question, or the question flowed from the visual.
Yeah.
So it was actually pretty freeing, just in terms of the courtroom setup. Probably the most difficult thing was sidebars. So we had the social distance at sidebar. So if you were asking questions, you were allowed to have your mask off. And then when you went up the sidebar, the judge wanted you to have your mask back on. So now, if you can imagine the judge, and then the defense lawyers are at the one side of the bench, and then the bench kind of like cuts off where the traditional witness stand would be, and then the court reporter was there. So the court reporter would basically go into the witness box, and then I ended up having to sit like side saddle on the railing in front, so that the judge could hear me, and we'd be social distanced and could hear the defense, and then they would be able to have the appropriate white noise. So that was really unique. But the case tried really well. I mean, everything went in pretty smoothly. And again, I think it was because, we really worked super hard on making sure that every single thing had some corresponding visual that the jury could be able to see and take, and had a real, takeaway on it. But I tell you, we walked on eggshells every day, because the judge told us, before the trial, look, if anybody comes in the next day and they test positive, or their family members test positive, it's a mistrial.
Yeah.
And you put a lot of time, energy, and money into these cases, and we spared no expense, because it was a big case, and we treated it as such. And so that made for some sleepless nights during the trial, just like, oh, please, nobody test positive.
I bet. Now, how did you sequence your story to get to try to put the focus, I guess, more on the shipper instead of the other people being involved?
That's a great question. So my opening statement, essentially started with, George James, on this day, George James went to work and never came home. Why? And then we started, let me introduce you to this company. And then I started talking about the company. And then I started talking about what the company did. Started talking about how experienced the company was with hazardous materials, how they handle hazardous materials all day, every day, et cetera, et cetera, et cetera. How they were, and then I explained the whole transportation cycle, shipper, carrier, receiver, because, and we had a great visual. I mean, just a terrific visual, with the company and the company's logo, and then, the truck, and the machine, and then their company. So it was really easy for them to understand, like, the bookends of this site, this movement was this company. And so, and then we introduced the federal regulations, and spent a lot of time, as one of the things that I love Rodney for, and I think that he's a true genius, is taking your jury instructions and applying them to your case, and making damn sure that you talk about them in your opening, you talk about them with your witnesses, because at the end of the case, those are going to be your foundation. Those are going to be your backbone. And we did that. And so, we broke down our jury instruction and the words, duty and responsibility. And then we had corresponding, those corresponded to words in the documents, as well. And so that's how it really kept the focus on the defense. And then from a sequencing perspective, my first witness in the case was the corporate representative of the company. And my cross of him was probably maybe a half hour. And he did terrible. I mean, he just, he came off very smug, a little bit angry. And even though, he had agreed that they didn't take any of these steps, they just kind of kept defaulting to that. We didn't have anything to do with it. We hired these guys, that was it. We didn't have to tell them anything. And so, once we were able to show the jury, no, you have the responsibility, not this company. This was your responsibility. And how did you fulfill it? It was I think it absolutely set the stage for the rest of the trial. And then the other, so we went from like the corporate representative, into our expert, and then into some of the folks from his work. And that was where we were, most concerned with our case, is that, the defense was going to be able to make some points crossing the owner of the crane company, crossing the co-employee. And at the end of the day, these guys were just brutally honest. I mean, they came in and they said, look, we don't have a hazmat certificate. So why would we even ask a hazmat question? We don't even have that certificate. And they know we don't have that certificate because we've been working for them for 20 years. And the only time we've ever moved anything that has had any hydraulic fluid in it is it's been in their facility from point A to point B, not on a roadway. And so these guys were just, they were just like your blue collar, super honest guys. But then when they talked about this guy, their coworker who they had worked with for 30 years, you saw these really tough guys just break down and start crying. And it was powerful. And then, so, every day, every single solitary day, they kept putting more money on the case after they told me, in the beginning, we're not going to pay you A. And then they went to, never going to pay you B. And then they went to, we're never going to pay you C. And then it finally got to the point where they, it was the last day of trial. And I said, I'm going to rest. And they said, I didn't call my economic expert.
Right.
The judge said, you're going to call any other witnesses? Not calling any other witnesses. And I was never going to call the economic expert.
Yeah.
And so the defense, so we take a break, and the defense says, well, Judge, we're going to call our economic expert. He's here. And they had said this the night before, and I didn't say anything because I was hoping he showed up. Right. I was really hoping.
They want to put in your economic damages because they think it's going to anchor the jury lower.
Right. So I say, she's like, well, do you have an objection? So I don't have an objection. Now, by all rights, they were so dumb that they made two critical errors. One, in Pennsylvania, the only way I get reckless indifference is on a survival action, not a wrongful death action. Okay. So if I don't put anything in on the survival action and they don't put anything in on the survival action, then I don't get reckless indifference in the case. So it was a little bit of a gamble on my part, but I knew they really wanted to do this. And now reckless indifference, if I get the check mark on recklessness, which it was headed that way, it would eliminate any comparative negligence on my guy's part.
Oh, wow.
Yeah. So it was like one of those moments where they're like, well, we're going to call our economic expert. What do you think of that? I'm like, well, thank God. So they're going to call this guy. So they put him up, and I knew that this was like a throwaway expert for them too, because the lead attorney, he lets his associate handle the economic expert, and I'm like, oh, it's gonna be fun. So I get up on cross, and the first thing out of my mouth, because their economic expert said that my 61-year-old guy that people have been raving about what a wonderful human being he was, that his economic damages were $62,000. It was an offensive number. It was appalling. So I get up and I say, let's do some math. And again, I didn't have any numbers in this case. I didn't put any numbers in. And I said, can we agree that every minute of life is important? Yeah. George James is 61. He's got, life expectancy of X. How many minutes is that? It turned out it was like 11 million minutes. So boom, right up on the big screen, 11 million. And it stayed there.
Because you don't get to ask for a number in closing in Pennsylvania,
Correct.
right?
Correct. So we have to weave in some economic numbers, and we had put another anchor that was just as big regarding the time, the value of this machine. So it all tied together on the anchor aspect of it. And so then for the next 20 minutes, I cross them, and so I start there, and then I said, you're the economic expert. Yes. Okay. And the jury instruction in Pennsylvania. Yes. And he's also a lawyer, by the way.
Oh, wow.
I said, and you're also, you're aware life expectancy, this jury must consider on the issue now of economic damages that you're putting into this case. They have to consider the type of person that Mr. James was. Did you do that? No. I said, well, let's take a look at the type of person he was. And Michael, for the next like 8 minutes, I went through photograph after photograph. This is Mr. James coaching softball for a kid who's not even his kid. This is Mr. James getting an award at work with his coworkers. This is Mr. James at the wedding of his daughter, which, by the way, he paid for the reception for the wedding for his daughter because his daughter's parents were having a hard time financially and never told anybody ever. So did you take that into consideration? Did you take this into consideration? And it was just boom, like one thing after another, just getting totally destroyed. And then I say to him, his name's Chad Stoller, and I've crossed him a bunch. I said, Mr. Stoller, I know you. I respect you. I know you on a personal level. And I know, you're a father, you're, a husband. And those things are far more valuable than any economic number. Wouldn't you agree? And he says, well, that's a interesting philosophical question. I said, it is. And I said, would you agree with that? He said, yes. And I said, you're not telling this jury that Mr. James's life is only worth $62,000, are you? And he said, no, no, I'm not. And then he went on like some big spiel about mathematics. And I just sat down. And after that, corporate counsel for the company was there that day, and the lawyer for the excess carrier was there that day. So we break, and now we're going to come back in the afternoon, and they come running up to me, and they're like, this case is getting settled. This case is getting settled. That was, ridiculous. And so, they put a lot of pressure, the excess carrier, there was a primary and then, basically two levels. And so we got the case settled, right then and there. But as a little interesting, aside, so another lawyer had ended up like coming into the courthouse and had to go in, to like where the judge was for some criminal matter or something, and was talking to one of the judge's clerks, and they're like, oh, how's Ed's trial going? And they said, well, it was going pretty good until about a half hour ago. and went from good to unbelievable after they put their economic expert on. And so, it settled, right after that. And, as a closing, the family, they were able to buy a house and, move out of, they were in a, tough living circumstances. And, they just sent me the most beautiful, Christmas card. And, those are the things that, when it all comes together, what we do, makes it, really makes it all worth it.
Absolutely.
Enjoying the episode? Do you wish you had Trial Lawyer Nation on the go? Well, wish no more. The Trial Lawyer Nation app is available now exclusively on iOS devices. Access our entire podcast library, create a favorites list, search for old and new episodes, and much more. It truly is Trial Lawyer Nation at your fingertips. Download this free app now and enjoy the top legal podcast for plaintiff attorneys wherever you go.
Did anyone get to talk to any jurors after the trial?
Yeah. So interestingly, the case settles, and, because of COVID, the judge didn't want to bring them back into the courtroom. Basically what the judge did is she just had her clerk go and tell them their services were no longer needed. The case had resolved. So I had asked the court if we could reach out to the jurors, and said, yeah, no problem. So sent each of the jurors a handwritten note and just said, hey, thank you for your service. I know you probably have some questions, and if any of you, want to reach out and talk about, the case and what happened, I'll tell you everything that I can tell you. And of the 12 jurors, 8 of them reached out to me.
Oh, wow.
And they were, I tell you what, Michael, they were, each one of them was better than the last. Like, they were just such amazing people. And the thing that I had asked them, each one of them, I said, like, were you nervous? They said, you know what? We were very nervous. We were very nervous about being there. But then, the judge put us at ease. The court staff put us at ease. Everybody was respectful of wearing a mask. Nobody kind of came into an area that made anybody feel uncomfortable. You kept checking in with us all the time to see if we heard everything, if we saw everything, if we needed anything. And they were all like, that made us kind of not forget that we were in there during COVID, but at least that everybody was doing everything they could to protect us. And that was good. That was, that was great. And, we kind of asked them about all of the points that we had talked about. And I mean, they were dead on. They were all 8 that we talked to. They were all with us. They hated the defendant, from the get-go, loved our family. And I said, if there was like one moment in the case that you really take from you, like the other, I did well or poorly, because I always ask, what could I do to get better on? And the couple of the jurors are like, well, that economic guy, like it was just, I can't believe that they even put him in there, and you did a really good job with that. And I said, what did I do? What did I do poorly? If there was anything else that I could have done that would have made things, better or easier, or, anything of that nature. And one juror said, you got to wear different shoes. I said, got to wear different shoes. Why do I have to wear, different shoes? She said, because the one day you were standing there and when you would move your foot, because the floor was, at that one area, it was like a tile. Uh-huh. She's like, every time you would move your foot, I could hear like a little squeak from the rug. Okay. I'm like, if that's the worst,
that's awesome.
If that's the worst thing, then that's fine. But No, they were just good people. They were just nice people. They were kind people. And none of them had an axe, none of them had an axe to grind. And I think we just, we got a little bit lucky. We had just people that were willing to serve and were okay with it. And we did the hard work beforehand so that we put ourselves in the best possible position to be successful for our client. And, fortunately we were.
I guess, I've got kind of two closing questions for you. One, for people that are wondering, should I push a case to trial during COVID, or should I wait till everyone's vaccinated and we're back to normal, or the new normal, whatever it's going to be, because they're scared about the uncertainty? What would you?
Yeah. I say do it. And the reason I say do it is, look, it is scary, and it is frightening. But we also have a job to do. And we have clients to represent, and those clients need us. And a lot of times, their financial futures are riding on us. And if we just focus on the uncertainty and the scariness of COVID, then I don't think that we're doing our job as lawyers and advocates, for them. I think you got to do it, and you really got to focus, and you got to work, 4 times harder than you do for a normal trial. But if you put in that work and do it, I think that you can overcome that uncertainty and those uneasy feelings, and that how really scary it is. I'm a firm believer in that.
What if your only option had been trial by Zoom?
Yeah, I don't know, honestly, and that's tough because just as you have, we've been doing depositions over Zoom for the better part of the last year, and they're okay, but they're not perfect. They're not great. And if your only option is trial by Zoom, then you got to do it. But I think the same thing is now, like, what are the things that you got to work on Zoom? All right. You got to work on, your eye contact, your hand. You got to work on visuals. You got to work on screen sharing. You got to work on your background. All those things that you really got to make sure that are perfect, so that A, they're not distractions, and B, now through this particular type of medium, that you're communicating as effectively and as efficiently as you can. So I think it can be done. It certainly presents a whole plethora of unique challenges, but I definitely think it can be done. And then there's also the way that Zoom is set up. I also think that there are some things that are better, in terms of trying a case, because you're going to see immediately somebody's reaction to a piece of testimony or a piece of evidence or a visual, as opposed to in a jury trial. Just because of where you're at, you may miss that, but you sure as hell aren't going to miss it on Zoom. And if it's something that you're keyed into and your people are keyed into, and you pick up on that, then I think that the body language over Zoom can tell you a lot, and it can be very intimate, as well. And you'll know. You're going to know over Zoom. You're going to know when people are engaged because they're going to get closer. You're going to know when they're just checked out because they don't care. So I think that you'll be able to from that perspective, pick up on some things that you might miss in a courtroom, just because of the spatial elements in a courtroom.
Yeah. Another thing, just for anyone that's thinking about doing the Zoom trial, and you don't have to just sit in front of the computer. There are other kind of cameras that can be used as web cameras. You can get someone operating a camera. You can stand up. You can move. You can get a printed board and have someone zoom in on it.
Yep.
So you can use mixed media. You can hold a model and have someone zoom in on it. So, be creative if you're going to do this stuff. And
we bought a thing called a Gigabot.
Okay.
And it's really cool. It has a remote and it's a camera. So the camera goes on this like little apparatus, if you will. It's called it. And so now like I could stand up and I could hit zoom and it'll zoom in on me pointing to something in the background. Yeah. So it's super cool. I mean, there's so many things that you could do in terms of, lighting and microphones and cameras and camera angles and,
and
all of
the cameras too. I mean, and one thing I like about document cameras as opposed to electronic exhibits, I crossed a defense medical, I don't like calling him expert, paid opinion witness, a medical doctor they hired. And then I had a client that had, just really, really exceptionally horrible injuries immediate. I mean, severe traumatic brain injury, lots of broken bones. And so one day I just got an outline of the body and I just went through him and, and they were all in his report. And so he had just marked and ready, a severe traumatic brain injury. And I wrote that out and I just went through each one and created the exhibit live.
Yeah.
Zoom so that, it's just more engaging and got it all from a defense witness that we can, play before we play our witnesses and give it even more credibility.
No question about it. And that's one of the other things that we've been working really hard on in depths because we know that, look, these clips from these depths are going to end up being in our trial. So how are we, what have we been doing? And we've been doing the same thing, like creating exhibits during Zoom so that when people are watching this, they're engaged, they see something, they see movement, and the yes no matrices that we've been doing those live, lots of graphs, because it's we can take tons of information and distill it down into one visual that people are looking, and they're looking at it. You see them when they're on the Zoom, like they're interested in it. They want to see what's on, what's on that. So there are some aspects of the Zoom trial that I think certainly can be better than even in a real courtroom. But end of the day, I know you're I wouldn't call you a trial lawyer. You're a warrior, and I know that you're going to go in there and slug it out and do everything you can to put your clients in the best position to make a recovery. And I just have such respect for you, Michael, in doing that because you've had, you got tremendous results and your passion, your passion speaks for itself.
Thank you very much, Ed. I really appreciate you joining us. If someone here is listening and they want to reach out to you, either because they got a case they want to talk to you about or they just have, an issue that they want to discuss with you, what's the best way to reach you?
Sure. So my email is ejc@fclawpc.com, ejc@fclawpc.com. And then the best way to get a hold of me is on my cell phone, 570-510-9941. As all of us, it's always right. It's always right there and it's always on and, drives our families crazy every now and then, but, feel free to reach out, anytime if you have any questions or, comments or want to get a little bit more information or talk about a case, whatever it may be.
Thanks, Ed. I really appreciate you coming on today. I've really gotten a lot out of this. I really appreciate it. You've got me fired up to try to get back in that courtroom.
Cool. Thanks, Michael. Good luck next week.
Thank you for joining us on Trial Lawyer Nation. I hope you enjoyed our show. If you'd like to receive updates, insider information, and more from Trial Lawyer Nation, sign up for our mailing list at triallawyernation.com. You can also visit our episodes page on the website for show notes and direct links to any resources in this or any past episode. To help more attorneys find our podcast, please like, share, and subscribe to our podcast on any of our social media outlets. If you'd like access to exclusive, plaintiff lawyer-only content and live monthly discussions with me, send a request to join the Trial Lawyer Nation Insider Circle Facebook group. Thanks again for tuning in. I look forward to having you with us next time on Trial Lawyer Nation.
Each year, the law firm of Cowan Rodriguez Peacock pays millions of dollars in co-counsel fees to attorneys nationwide on trucking and company vehicle cases. If you have a case involving death or catastrophic injuries and would like to partner with our firm, please contact us. We have experience finding potential defendants that other firms miss, and we've added millions of dollars to cases by finding these sources of recovery. If you have a catastrophic injury or death case where the policy limits appear to be insufficient, give us a call. If we can find another defendant, we can partner on the case. And if we can't, then we won't ask for any of the fees. You can reach Delisi Friday by calling 210-941-1301 or send an email to podcast@triallawyernation.com. She will coordinate a time for Michael Cowan to speak with you in person or by phone to discuss the case in detail. This podcast has been hosted by Michael Cowan and is not intended to, nor does it create the attorney-client privilege between our host, guest, or contributors and any listener for any reason. Content from the podcast is not to be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.